Good morning or good afternoon to all of the participants who are joining us right now. My name is Sebastian Deck. I'm with the Center for International Environmental Law. I just would like to welcome you very warmly for this side event and COP26 pre-briefing. We'll be starting in just 3 minutes for time for people to join us, but we really appreciate your presence today with us and hope that we'll have a very lively conversation. And we'll introduce the event in just a couple of minutes. Thank you, and look forward to your active participation. Good morning, everyone. Good afternoon. So we are about to start now. We would really like to welcome all of you who are here with us today for this first side event. And I will provide a little bit of context on why we are organizing this event and who are the audiences invited before I actually introduce our guests today, who are very distinguished and experienced experts in the field that we are going to discuss. So my name is Sebastian Deck. I'm with the Center for International Environmental Law, and we're very pleased to welcome you today for a conversation on public participation in international climate governance, with a focus on the Aarhus Convention, but not only. And the reason why we will focus on the Aarhus Convention, the convention that was adopted by European, Central Asian, and now an African country, to protect the right to access to information, public participation, and access to justice in environmental decision-making, is that this side event is actually the first side event of the once in every 4 years meeting of the parties to the Aarhus Convention, where the 48 states that have ratified the Aarhus Convention convene to discuss actually and review how the progress they are making in meeting their obligations under this Aarhus Convention. So we'll focus a little bit on that aspect today, but most particularly our eyes will be looking forward and trying to understand what have been the good practices of the past, the challenges faced by advocates at the UN climate conferences, the annual COPs, but also what are the expectations then on the COP26 that is going to meet in just a couple of weeks. Or in 3 weeks, sorry, in Glasgow. And so the panelists today are going to reflect those different perspectives, helping us understand what are the legal obligations of states to promote public participation, not only at the national level, but even at the international level, from a Aarhus Convention perspective, but also from a global perspective. I'll introduce the first 2 speakers in a minute. And then we will shift really to focus on the experience at the climate COPs, focusing both on the way that the climate COPs are actually promoting the implementation, the protection of those rights in national climate policies, but also, of course, very importantly, how those rights are actually protected in the context of the climate COPs themselves, and the extent to which the civic space is protected in the annual COPs. I must say, before I introduce the panelists, I wanted to highlight also that this is a very particular moment, because just on Friday, actually, we saw the UN Human Rights Council actually adopt a resolution recognizing the universal right to a clean, healthy, and sustainable environment. And the purpose of the Aarhus Convention is to promote public participation in order to realize these rights. So at the core of the Aarhus Convention, and I think all of the conversation we're having today, there is this understanding that actually guaranteeing the right to public participation is an essential component, an essential prerequisite towards fulfilling the right of everyone to a clean, healthy, and sustainable environment. And so it's fantastic to be able to host this event today after 43 out of 47 members of the Human Rights Council have actually voted in favor of a universal recognition of this right. I think it gives us a very good starting point for this conversation to really explore the importance of these issues. I do not want to take the floor more, just a couple of announcements before we start with the panelists. The meeting today is recorded. We'll be circulating the link to all of the participants. We also hope to keep this meeting as a very interactive one. And so we are looking forward to questions afterwards. We hope also to really be able to hear some of you taking the floor from the audience. And finally, the format is 2-hour-long side events, because that's the format used by the Aarhus Convention Secretariat for the Aarhus Convention meeting that is taking place this week and next. We might keep the meeting a little shorter and instead invite you to make the most of the final 15 minutes to actually digest on your own the information shared, and for instance, explore some of the resources that we'll be sharing during the meeting in the chat. If there is any question on logistics, my colleagues and myself at CL are here to answer. Please do not hesitate to use the chat and to direct your questions to us. I would like to start then now right with the first presentations. And so again, we'll have 3 different kind of short conversations that all are interconnected and interrelated. The first one is going to be an overview of a right-based approach to public participation in international climate governance from a legal framework perspective. And there we'll have 2 important institutional speakers laying out actually what are the legal obligations of states to protect the civic space in climate governance at the national, but also at the international level. So first we'll hear from the Special Rapporteur, Clément Woul, who is the Special Rapporteur on freedoms of peaceful assembly and association. And he will be followed just after by Ms. Anastasia Giadrossi, I hope I'm pronouncing the name right, apologies if not, who is an expert from the Aarhus Convention Secretariat and will be speaking about from this Aarhus Convention perspective, right after Clément Woul. I will introduce Mr. Woul first, but I also wanted to highlight that we are particularly pleased to welcome his presence today, not only because he helped us in the past with some of the issues that we faced at the UNFC, and we might come back to this when we discuss the experience of Tatiana Shaoro and other activists who faced some challenges in the past attending the COPs, but also because actually Dr. Woul's report, the latest report is related actually to climate justice and freedom of assembly and association. So an extremely timely delivery of input, and we really look forward to hearing his input. We'll share the names of all panelists in the chat. I'll keep introduction extremely brief so that you can maybe find more information on the internet if you need. Mr. Woul was appointed as a Special Rapporteur on the rights of freedom of peaceful assembly and association in 2018, and previously has been supporting a lot of human rights defenders in state in transition, including working for the International Service for Human Rights. And so his latest report right now is particularly relevant because of its focus on climate justice and freedom of assembly and association, which is really at the core of the conversation today. Mr. Woul, I give you the floor for about 10 minutes. Thank you.
Thank you. Thank you very much, Sebastien. Good morning, members of the panel and friends of the United Nations, civil society, and the regional organization who are connected with us today. I would like to thank first the Center for the International Environmental Law for inviting me to this important discussion. And it is really a good pleasure to be with you today. The right to freedom of peaceful assembly and of association are fundamental freedoms that enable individuals to express themselves collectively and to participate in shaping their societies. They are essential components of democracy and the full enjoyment of civil and political rights and economic, social, and cultural rights, and drivers of the achievement of the Sustainable Development Goal. These freedoms are crucial in the context of environmental protection, and most importantly, in the context of the climate crisis the world is facing. In the report that you mentioned, Sebastien, that I will be presenting in a few days to the General Assembly, I stress these rights are intrinsically intertwined with the right to public participation. Together, they are the most important tool people have for advocating for the more effective and equitable climate action and environmental protection. Climate change is already causing environmental and economic damage in many parts of the world. This crisis is dramatically changing how people live their lives. It will affect the future of all of us, but its impacts will fall disproportionately on the poor and vulnerable. The World Bank estimates that without immediate action, climate change could push 120 million more people into poverty by 2030. As the International Panel on Climate Change has affirmed, the world can address this crisis by the acceleration of far-reaching, multi-level and cross-sectorial mitigation and transformational adaptation. These ambitious measures cannot be achieved without the full engagement of citizens and their communities. The right to peaceful assembly and of association play a critical role in facilitating that engagement. It allows individuals and community to advocate ideas and aspirational goals where they are used to air grievances. This freedom can create opportunity for the inclusive, participatory, and peaceful resolution of conflicts. In my reports, I highlight the value of Indigenous Led Protest movements around the world that have sought to defend their land against the impact of fossil fuel, agribusinesses, and infrastructure projects for decades. In Australia, activism by Aboriginal and Torres Strait Islander people, for example, help secure ambitious climate commitment from the private sector. The right to freedom of peaceful assembly and of association plays a key role in opening up spaces and opportunity for genuine and effective engagement of individuals and communities in environmental and climate decision-making process. For example, in Argentina, civil society and protest action by young people led to the adoption of national legislation aimed at addressing the climate crisis, including commitment to ensure public participation and access to information. This is extremely important, given the competing interests that are intrinsic to environmental matter and climate action policies. The right to peaceful assembly and association can also help foster increased transparency and accountability and help expose cases of corruption of vital resources to climate adaptation and mitigation. But the reality, however, is that states generally do not respect or facilitate the right to freedom of peaceful assembly and of association in the context of climate governance. And especially, these rights are often violated in the context of natural resources exploitation, including commercial activities aimed at shifting to renewable energy. In fact, the space to exercise this freedom is often more limited in relation to the natural resource exploitation because of the significant impact this sector has on the economy of resource-rich countries, the bottom line of the enterprises involved, and the potential for corruption. In this context, the right to freedom of peaceful assembly and of association are often approached with a national security lens, including through repressive regulation, surveillance, criminalization, and hostile rhetoric. In my report to the General Assembly, I document some of these trends in restriction. Governments have implemented assembly ban for climate strike and protests, including banning specific protests and limiting or denying requests for climate-related assemblies. Governments have arrested scores of climate protests, engaged in peaceful protest action, and passed laws to criminalize formerly legal protest methods. Laws specifically targeting activists protesting around critical infrastructure have proliferated, particularly in the US. This law creates new felony offenses, typically for trade-power, oil, and gas industry infrastructure. Climate activists are frequently framed as extremists, inciting communities to resist and disrupt development projects. They face unnecessary and disproportionate barriers to access to funding, particularly foreign funding. And as you know very well, they are under constant trends of violence, with over 70% of human rights defenders killed every year involved in the protection of the environment. This security-based approach on climate change will not result in transformation, adaptation, and mitigation we need. To be effective, climate change response should be based on respect for human rights, which require that governments engage people and communities. The COVID-19 pandemic has once again demonstrated that in the time of crisis, government policy cannot be effective without people participation and trust. In other words, in time of crisis, having citizen engagement is an imperative. As I said before, the right to freedom of peaceful assembly and of association provide the necessary avenue for this engagement. A security-based approach characterized by the stigmatization and criminalization of environmental and climate defenders and peaceful protests is not only unacceptable under the international human rights law, but counterproductive. The urgency of climate action means more people will be involved in activism and protests. States will be prepared to respect, protect, and facilitate civic space and engagement with organizers and participants in meaningful dialogue. Thank you for listening to me.
Thank you so much, Special Rapporteur Wool, for your input. In your presentation highlighted the importance of legal obligations that already apply to state, but also the challenges that we keep seeing all around the world. And unfortunately, the realization that actually protesting against climate harmful activities is one of the greatest, or puts you at greater risks of being actually target of harassment or violations of breaches of your human rights in so many countries around the planet, really on all continents. And so I think from this perspective, and I invite everyone to really look at the link that has been shared by my colleague in the chat, open this very recent report by Special Rapporteur Wool to further explore those linkages. At the light of this, we will now transition to a second legal framework that actually, in addition to the global human rights framework that provides very specific obligations for state to protect procedural rights of citizens in environmental decision-making. And we'll focus a little bit more on this aspect of protecting the civic space in international governance, because we know that if we want to hold governments accountable for breaches or for undermining the civic space, not protecting the civic space in climate policies at the national level, the first thing that we need to do is to make sure that we actually set an example at the international level, and hence the importance of ensuring that this civic space is fully protected in the context of the international climate negotiations, for instance. So now I will give the floor to Ms. Anastasia Giadrossi. We are particularly pleased to welcoming her today because we understand that the Aarhus Convention Secretariat, where she works as an associate expert, is under a lot of pressure at the moment, preparing the once in every 4 years meeting of the parties taking place officially next week. This week is the week dedicated to side events. We'll post the link to the side event program in the chat also for others who are interested in exploring the different side events. Ms. Giadrossi, prior to joining the Aarhus Convention Secretariat, was working on issues related to access to justice and adaptation matters. And we look forward to hearing the view of the Aarhus Convention Secretariat, in particular with a view to protecting those rights in international climate governance. You have the floor now.
Thank you, Sebastian. Please confirm that you can see my screen. 1 second. I have prepared a presentation. How about now? Do you see my screen?
We can see it. It should probably be turned still into a presentation mode. Yes, now it's excellent. Thank you.
Okay, thank you very much, and good morning, everyone. I would like to thank very much the organizers of the event, the Center for International Environmental Law, Earth Justice, and the European Environmental Bureau for the opportunity to deliver the presentation today about the promotion of the principles of the Aarhus Convention in international climate governance. And for those who are not familiar with the Aarhus Convention, its full name is the Aarhus Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters. And it entered into force in 2001, and this year actually marks the 20th anniversary of the entry into force of the Convention. It currently has 47 parties from across the UNEC region, however, it is actually open to global accession from other member states of the United Nations. And we hope next week at MOP 7 to welcome the accession of Guinea-Bissau as the first African country to join the convention. And the Aarhus Convention is a legally binding instrument on procedural environmental rights. It enshrines the rights to information, public participation, and access to justice in environmental matters. And parties have an obligation under the Convention to promote these rights both at the national but also at an international level. And I wanted just to quote the preface of the Aarhus Convention Implementation Guide, which very much goes at the core essence of the instrument. The Convention goes to the heart of the relationships between people and governments, and it is an agreement about government accountability, transparency, and responsiveness. As with any legal instrument, definitions are crucial in defining the scope of the Convention, and the Convention grants the rights to the public and the public concerned. And by public, the public is defined as one or more natural legal persons, and in accordance with national legislation or practice, their associations, organizations, or groups. And also to the public concerned, which is defined as the public affected or likely to be affected by or having an interest in environmental decision-making, but also NGOs promoting environmental protection that are recognized under the national legislation. And the Convention also enshrines a principle of non-discrimination, which means that rights apply regardless of citizenship, residence, or domicile. And based on Article 3, Paragraph 5 of the Aarhus Convention, parties to the Convention have an obligation to promote the application of the principles of the Convention in international environmental decision-making processes and within the framework of international organizations in matters dealing with the environment. And in order to implement Article 3, Paragraph 7 of the Convention, the meeting of the parties in 2005 adopted the Almaty Guidelines on promoting the application of the principles of the Aarhus Convention international forums, which aim to provide parties with guidance in terms of the development, modification, and application of relevant rules and practices applied within international forums, such as access to documents and meetings, statements delivered by observers, but also the treatment of relevant substantive issues within those forums. And the implementation of Article 3, Paragraph 7 of the Aarhus Convention is assessed by the Working Group of the Parties, which is the highest intercessional body of the Convention, on an annual basis in a dedicated thematic session. And several times there were a thematic section was focused on UNFCCC processes, and at these sessions, parties, other stakeholders, and also the UNFCCC Secretariat are invited to share their experiences, practices, and challenges in relation to the promotion and application of the principles of the Aarhus Convention within this forum. And looking more closely at the content of the Almaty Guidelines, with respect to access to information, parties should encourage international forums to develop and make clear, to develop and make public a clear and transparent set of policies and procedures on access to the information they hold. And any member of the public should be able to have access to information developed and produced within the international forums in a timely manner through internet or other appropriate means. Information should be also shared proactively, and any refusal of information should be interpreted restrictively and should be based on specific grounds. With respect to public participation in international forums, participation is crucial in terms of ensuring the quality of decision-making and the acceptance of the outcome, and it should be as broad as possible. Thus, any restrictions should be applied only if absolutely necessary and unavoidable for practical reasons. And where there are certain accreditation or selection procedures, these should be based on clear and objective criteria. Public participation in international forums means also the right to access all the relevant documents produced during the meeting, having the right to circulate written statements and speak at the meeting. And with respect to access to information, parties should encourage international forums to consider the establishment of a review procedure related to the application of the forum's rules concerning access to information and public participation. And finally, another important principle of the Almaty Guidelines, which is very much relevant for the upcoming COP26 negotiations and also the challenges related to the COVID pandemic, to ensure that all members of the public and delegations of least developed countries, NGOs, and interested stakeholders will be able to attend and voice their concerns at the coming negotiation. Paragraph 15 is very much relevant, and it aims at promoting special measures to ensure a balanced and equitable process within those international forums, and also further recognizes the importance of facilitating and supporting those constituencies that are mostly directly affected, but may not have the means for their participation. And looking at the substantive issues, at MOP 6, so the meeting of the parties in 2017, the Aarhus parties have adopted a decision on the promotion of the principles of the Convention in international forums. And through this decision, they agreed to focus on forums dealing inter alia with climate change. And also they encouraged the parties to promote the principles of the Convention in relation to work programs, projects, decisions, instruments, and substantive outputs of those forums whose practices currently do not reflect the Aarhus Convention principles and the Almaty Guidelines. And finally, I would just like to conclude with some to address the role of the host country in promoting public participation in international processes such as the climate COPs. These host countries are responsible, among other tasks, with dealing with logistical arrangements, but also enabling the participation of interested stakeholders in this process. And countries parties to the convention in the role of host countries are bound to ensure that all preparations and negotiations proceed in the most transparent and participatory way possible. And on this topic, I would just like to quote some statements that have been delivered at the Aarhus Convention Working Group of the parties by parties to the convention in dealing with their promotion of public participation in UNFCCC processes. And France reported with respect to its role in host country at COP21 on the choice of keeping space between civil society and negotiators close to one another to encourage an interaction between negotiators and other stakeholders. It also has reported on higher number of badges being issued for observers and access granted to members of civil society to non-accredited to reserved spaces at the COP venue. And finally, the UNFCCC Secretariat has reported in 2009 on the experience of Poland as a host country of COP24 in Katowice, and has explained that the party in this case had ensured that there was a higher number of organizations being admitted as observers, that certain meetings were open to observers as well, and that there was an ongoing open dialogue had been ensured by the host country between the parties and observers for the sharing of practices and experiences. But it also highlighted some important challenges which were related to the physical constraints of the COP venue and the high number of participants, which did not allow for certain constituencies to have and to carry out their meetings. And I would just like to finally conclude by pointing at some certain documents, including the Almaty guidelines that I've mentioned, that are useful references. And in case you would like to contact the Aarhus Convention Secretariat, please do not hesitate to reach out to us at this email address. And thank you very much for your attention.
Thank you so much for your presentation, Ms. Giadrossi. We really welcome the support of the Secretariat, the Aarhus Convention Secretariat, in our efforts to promote public participation in the climate governance spaces in the past. We have been able to actually organize capacity building briefings for delegates from the Aarhus Convention parties at the Climate COP with the help of a UNEC Aarhus Convention Secretariat to actually highlight what obligations exist for these states to promote public participation in the context of the climate negotiation. And to our dismay, I must say, it's been very surprising for us to realize how many climate negotiators will come to the climate COPs without understanding that their country is under the legal obligation in no ambiguous terms to actually promote public participation in international environmental decision-making. And the wording of this Article 3.7 that Anastasia has highlighted in her presentation is really as strongly as worded as it could get. There is no question that this is a legal obligation. It speaks about the duty of states to promote and using the word shall, which leaves no ambiguity, no room for interpretation. So this is very helpful reminder that in addition to the international human rights framework described by the special rapporteur previously, we have legal instruments that are providing legal obligations to a very wide number of countries in Europe, Central Asia, and now Africa, with the ratification by Guinea-Bissau of the Aarhus Convention, but also just to mention very briefly to the Escazú Agreement in Latin America and the Caribbean, where 24 countries have signed these historic agreements mirroring and expanding beyond the Aarhus Convention's provisions, and including also very similar provisions when it comes to the duty of states to actually promote these rights in international environmental frameworks. And I will invite anyone interested to really review the provisions of the Escazú Agreement that entered into force earlier this year on Earth Day, and in particular, it's Article 4.10 and 7.12 that provide those legal obligations that are very similar to the one that Anastasia described. Now, moving forward, we'll focus on what are the lessons, what are the expectations, what are the challenges that those legal frameworks really provide for the climate governance negotiations, and in particular for COP26, but also looking a little bit back. And we'll do so with two different focus that really mirror what the previous presentation highlighted. States have an obligation to do two things when they engage in the climate negotiations or in any other international decision-making processes related to the environment, even if the environment is not the core focus. The first one is to promote those principles of public participation in the outcomes. And so it's very encouraging, for instance, to see that the Paris Agreement has a full article dedicated to public participation and access to information. It's Article 12. But then the key question for us is how those principles really reflect in guidelines that are provided by the climate COPs, for instance, for the national implementation of those agreements. How do we make sure that we provide guidance so that states systematically implement those agreements on the basis of those principles that have been discussed? And for this discussion, we'll have the first two speakers. And then finally, we will move to the final topic of the day, which is, and as importantly, how do we make sure then that the civic space at the climate governance, at the climate negotiations is guaranteed and protected? And we'll hear from a diversity of voices also to look at some of the good practices of the past and some of the challenges ahead. So first, to focus on the importance of public participation in substantive outcomes that are expected this year from the COP26 in Glasgow, we will have the pleasure of welcoming Ms. Salka Sigurdardottir, who is the head of cross-cutting issues in the UK COP26 team. And we are very happy to welcome her today because we understand that the COP26 presidency has quite a heavy workload, obviously, at the moment. I must mention that Salka will unfortunately need to leave at the top of the hour. So we'll invite you to raise questions in the chat if there is any question that you would like to provide, and maybe we'll pause after her presentation to see if there is some immediate responses that need to be provided. Salka is working in particular on negotiation mandates that relate to inclusivity, empowerment, and the COP institutional framework, and this includes two particular items that are direct relevance to today's discussion, which is action for climate empowerment and arrangement for intergovernmental meetings. And so, Salka, I'll give you the floor.
Thank you very much, Sebastian, and everyone who spoke before me as well. And well done for making it here on an early Monday morning. I've been asked to talk a bit about the work of the presidency to promote public participation in the process leading up to COP and COP itself, but equally some of the outcomes of COP26. This is, of course, reflected in the Aarhus Convention, but also in Action for Climate Empowerment and on a few other frameworks, which I'll talk about later. But in essence, we see this as making sure those affected by a decision have a chance to be involved in the decision-making process. And it simply makes outcomes better as inclusive and diverse perspectives is a strength, and we look at it as an advantage in how we expand the way we find solutions in the presidency. And you may have heard us talk about this, but we've been very committed to championing inclusivity throughout our COP26 presidency and use our presidency position to very much empower and amplify the voices and views of those who are often most marginalized and addressing their needs and priorities in the run up to COP and at COP itself. So for us, this means working with civil society and a diverse range of actors, including Indigenous peoples and youth, and to platform and learn from the voices most affected by climate change, and then also inspire governments to increase their ambition and to work with us and governments. And you know, this particularly applies to, say, women and girls, indigenous peoples, and other voice, particularly disproportionately impacted by climate change. But then they're also, at the same time, very critical agents of change and leaders within the climate response. And within that, we need to ensure that we're respecting and promoting human rights at the front of centre, and that human rights implications are amplified throughout the COP process. And we've been also very clear that each party should incorporate those considerations into the position they bring to the negotiation table and the national commitments they make. Within COP26 processes, we're doing this in many ways. So I'm going to talk a bit about the engagement, inclusion, and consultation processes we have before I talk about some of the mandates at COP. The COP president designated has established a number of advisory groups to guide our planning and delivery of COP. This includes a Youth and Civil Society Council, which is co-chaired by youth representatives, but also involving Indigenous peoples. We've also got a separate business advisory group. We're working with a very diverse range of friends of COP who are sharing our expertise to make sure the summit is successful and inclusive. And again, this also includes Indigenous leaders. And also to address Indigenous peoples briefly, ahead of COP, we've been working in partnership with the Indigenous Peoples Caucus to run a series of dialogues focused on Indigenous leadership and nature-based solutions. And we invited them to join our ministerial roundtables. And one of the things I did when I joined this job 2 years ago was to establish very close relationships with the caucus and let them define the way they want to run the engagement with the presidency. So we've had very regular meetings, brought in our policy teams to speak to the Indigenous caucus and let them advise us on issues and be led by them about what platform and how to guide things forward, because we recognise very much their knowledge and expertise. I've also announced that we're going to be funding a dedicated Indigenous Peoples Pavilion at COP26 in the Blue Zone, which we're incredibly proud of. And again, the Indigenous Peoples Caucus will be organising that space themselves. I also want to talk a bit about gender equality. I believe very fundamentally that championing women's roles as decision makers, educators, and climate leaders is essential if we're going to deliver effective and long-term solutions to climate change. And we are committed to implementing the Gender Action Plan agreed at COP25, very much using our presidency platform to encourage other parties to do the same. So our objectives are twofold. One is to implement the Gender Action Plan in our own national frameworks, to increase our own climate policy, increase gender equality in our own climate policies and finance, but equally use our presidency platform to encourage other governments to do the same and build that momentum around gender equality and inclusivity. It's very much a call for action for other countries to integrate gender equality into climate action. So we're organising a dedicated Gender Day at COP to amplify commitments to the Feminist Action for Climate Justice and Gender Action Plan, and working very closely with the Women Gender Constituency and UN Women and UNDP and other organisations to ensure Gender Day is shaped by those with the expertise and the local knowledge and links to grassroots. And I hopefully don't need to tell anyone here that intersectional approach to gender is very key to us, making sure to recognise layers of discrimination which aren't just limited to gender and are compound when you add race, disability or other characteristics. So the intersectional lens is really guiding anyone we work with, anyone we invite to speak and work with us. And then just on youth participation is very key. We have a very dedicated youth engagement team in the COP26 team, working with Youngo and a diverse range of youth organisations to plan a youth and public empowerment day at COP. And just the week before last, lots of us were in Milan working with the Italian government to host a Youth for Climate event, bringing together 400 youth delegates from across the world to talk about climate action, linking to pre-COP and COP. So those are just some of the things we're doing as the UK presidency, but we're also very much role modelling and using our platforms to encourage other countries to be inclusive. This includes encouraging a participatory approach to NDCs, adaptation plans, long-term strategies, finance commitments, ensuring they're seeking broad views, and then in general, removing barriers to participation in policy development and including seeking recommendations, working with directly on necessary policy projects and supporting that participation in COP itself. Now I'm going to turn to the institutional framework around COP, and I'm sorry, Sebastian, I feel like I'm speaking a lot here. I want to talk about ACE and the UNFCCC and a few other frameworks. One of the things I'm most excited about for Glasgow is negotiations on the review of the Doha Work Programme on Action for Climate Empowerment. And we hope to walk away from Glasgow with a brand new work programme on ACE. And ACE is such a pivotal framework, bringing together the elements that are very fundamental to achieving the ultimate goals of the Paris Agreement and the Convention, and it will help us enable the inclusive ambition that we want from COP. So those not familiar with ACE, it's essentially the UNFCCC work stream that institutionalized the fact that climate action is most effective when all citizens are involved and able to share their views. It's mandated by Article 6 of the Convention, Article 12 of the Paris Agreement, made up of 6 elements: climate education, training, public participation, public access to information, public awareness, and international cooperation. And I always find that a bit of a mouthful. But yeah, we can't achieve Paris goals without public participation, public access to information, and public awareness, because how else would we ensure public buy-in to climate policies and initiatives? And how else do we get broad ideas that work for everyone? And how else do we really work democratically to ensure that everyone's views is reflected in the way we shape climate policies? So for me, ACE really is a no-brainer, if you will. And it's also recognised as the work stream that most innovatively enables the party and non-party collaboration, which we really admire, and ACE consultations and expert groups to prep the negotiations have seen very high stakeholder participation inputs, and we've really seen how much parties welcome it, because if we're creating a work plan on public engagement, that needs to be shaped by an open process. And at COP26, we also have the review of the Local Communities Indigenous Peoples platform. COP25 agreed a 2-year work programme, and now COP26 will agree a new 3-year work programme. And again, this is a very innovative framework that brings Indigenous leaders directly into decision making via the facilitative working group. And I also want to highlight, as Tasmin knows, you'll hear from her in a bit, we've been working very closely with the 9 observer constituencies in the UNFCCC. And again, the week before last in Milan, I think we were the first presidency to ensure observers had a speaking slot, both at pre-COP plenary and at the closing plenary. And at the closing plenary, we made sure that observers spoke before ministers to make sure they were truly listening, and then ministers and policy discussion started. And Anastasia also mentioned the open dialogue with a presidency that gets to host not 1 but 2 open dialogues. We organised one in December 2020, and are now starting the process of organising the next one at COP26. Again, topic very much shaped by observer groups for what we can discuss and bring parties and observers together at COP. And we also been champions of observers in the UNFCCC process. In the SB sessions in June, we did active encouragement to parties to make sure to keep the UNFCCC rooms open, because as you may know, rooms are open to observers as in negotiation rooms unless some parties object, and we always encourage them to be open. And then I'm not going to go into the details of the green zone, but you will have seen we ran a big application process in spring to get a stakeholder application to the green zone. Again, very much led and shaped by the public and attended by the public. And we've now published our green zone programme. So I recommend taking a look at that. I'm going to stop there. I've spoken way too long. Thanks very much for listening to me. And thanks again for sharing your expertise and experiences as well. For me, this is very much a learning journey, and we very much welcome your input and want to hear lessons learned and best practices. So thank you.
Thank you very much, Selka, for this broad overview, but also for the work of the presidency on some of the issues that you discussed. Selka, unfortunately, we need to leave us in 10 minutes because of other commitments that she has with the hectic planning of the COP. And I would suggest that maybe we pause now and see if there is any direct questions specifically for Selka, either from other panelists or from the floor. And then afterwards, we'll come back to the final speakers who will be focusing on COP26 or modalities for engagement in previous COPs. But maybe let's see if we can make the best of Selka's time. Let's take the general questions afterwards so that we can make sure that several panelists can answer them. And just looking I see you, Augustine. I'm going to allow you to intervene so that you can take the floor if that's a direct question to Selka.
Thank you, Steph, and thank you, Salka, for this your intervention. My name is Augustine. I'm from the Pan-African Climate Justice Alliance, speaking from Cameroon. You know, the right to public participation in decision-making has to be guaranteed by public authorities. In this case, the right to participate effectively at COP25 has to be guaranteed by the UK. We see that some logistical issues like the prices of hotels in Glasgow are prohibitively high, and high in the sense that if developing country civil society groups cannot reasonably be able to pay. We saw that in COP22, I'm not by any way trying to do a comparison. Moroccan presidency facilitated the hotels and even had hotels for developing country delegates that were not able to pay for those hotels. Has the UK made any provisions to ensure that there's effective participation from these non-state stakeholders from developing countries, especially Africa, to have hotels at COP26? Because the right to participation and the duty to make sure that this participation rests in the hands of public authorities, in this case, the UK presidency. This is a direct question to Salka. Thank you very much.
Thank you, Augustine. Maybe I'll give you the floor directly, Salka, so you can address this.
Thank you for that, Augustine, and we're very much closely monitoring that situation, and I've heard of some horrendous prices. We had a system called the MCI that secured around a third of the market availability for hotel rooms in Glasgow and Edinburgh and the surrounding areas, which meant that we were able to secure a fairer cancellation deal and better room prices in the open market. Whereas for the rest of the accommodation, the terms and conditions are very much market-led, and prices have been set by hotel and accommodation providers themselves, rather than us as government or the system called MCI. So we continue to be in very close contact with the local authority in Glasgow and figure out the best solution and planning for, as I say, the block booking that we've already made. And yeah, I know it's a tough one, and we're trying our very best, and we've got a very dedicated sort of operations and hotels team trying to find solutions. And recognise staying in Edinburgh is also an option with the train, but unfortunately Glasgow isn't, and Scotland isn't a huge place, which is why it's been so incredibly challenging for us to manage this.
I wonder if there is any other direct question to Salka or to the COP26 presidency team that anyone would like to raise. I think those in the chat so far seems to be of a more general nature, so we'll come back to that afterwards, unless Salka, you would like to answer any of those. I think the point made by Augustine is a very important one, both in terms of the importance of learning from good practices, and we'll hear again from another set of good practices in relation to the COP23 presidency that was hosted by Fiji. The importance of bringing this human rights framework in the discussion around public participation, maybe compared to what we've seen more generally speaking in environmental climate governance frameworks, is that it really focused on the need for those directly impacted, those that have less resources maybe, but are more vulnerable, to really have their voice heard. And I think this Augustine's reference to these sort of corrective measures, really making sure that developing countries delegates have an opportunity to benefit from accommodation is a good example of steps that should be considered by hosts to ensure a balanced and equitable process. Any additional question for Salka? Otherwise, I will, so we'll make sure to share, of course, the recording from this event with the COP26 team. It's unfortunate that Selka couldn't join us for 2 hours, but we understand she has some other commitments afterwards. I will suggest then to move on to the next presentation that is going to focus also on another area of work under the COP26 agenda, where the rights of access to information, public participation, and access to justice are actually essential to ensuring that outcomes adopted at COP26 actually do not further infringe on the rights of local communities. And so I'll give the word now to Patricia Bolland, who is the coordinator of the Women and Gender constituency, and she's working a lot on Article 6 negotiations under the Paris Agreement, which relate to, among other things, carbon trading. Patricia works as a climate and gender policy officer in LIFE, a German-based organization which works with local communities, NGOs, and local governments to reduce greenhouse gas emissions, in particular in the transport sector. But she's been very active with the women and gender constituencies and have followed the negotiations very closely from this perspective. So Patricia, I'll give you the floor now. Patricia, we can see your presentation, but we cannot hear you in case you're trying to intervene. We can, Patricia, can you hear us?
I can hear you well. Can you hear me now?
Perfect. Now we can hear you very well. Excellent.
Okay, amazing. Many thanks. And I hope you can also see my presentation.
Absolutely.
Okay, great. Yeah, so I just said thank you for this introduction to SEP, and many thanks for the invitation to speak at this important side event on procedural rights in the context of Article 6 of the Paris Agreement. For everybody who has not been too much involved into the question of what market mechanisms are included in the Paris Agreement, I will just shortly have a look on the basics, what we can find in the Paris Agreement and why COP26 has such a large focus on Article 6, and it's all around probably if you have already heard about the COP26 agenda. And then I will go into the question on where we come from and why it is important to underline local communities' participation on public participation into the Article 6. So first, what's actually behind the famous Article 6. The Article 6 of the Paris Agreement covers the voluntary cooperation between parties to achieve their NDCs. And it covers actually market mechanisms as well as non-market mechanisms, but I will focus today on the market mechanisms a little bit more. And the reason why Article 6 is on the agenda is that there has been no decision on Article 6 and the Katowice climate package from 2018, nor could there be any decision being made in Madrid at COP25, which was the last climate conference that took place. And this is why there is such a large focus now at COP26 on this article. And the position, as I'm speaking from a civil society point of view, is that right holders clearly underlined for a couple of years already that the coverage of human rights safeguards and environmental safeguards are definitely the red line, and that no outcome is actually better than a bad outcome in this regard. So what is this article about? The article covers actually 3 elements. So the insiders, so to say, are always covering either on 6.2, 6.4, or 6.8, which is firstly the internationally transferred mitigation outcomes, so the big carbon market, so to say, then the sustainable development mechanism, which I will be focused on, and then also the framework for non-market approaches that is also very relevant for public participation. However, the development of the Article 6.8 has been rather slow in comparison to the other 2 articles, and the outcome is probably more kind of a work program style. So I have less focus in this regard. And also there seemed to be a larger likelihood that this article will actually cover human rights safeguards as well as public participation. What all article elements do have in common is that sustainable development, environmental integrity, transparency, and a robust accounting are actually common objectives for all approaches. So this, I think, is already linking quite clearly, for at least for our perspective, to the principles of a public participation and access to information, but also safeguards for human rights, which are of course also in the Paris Agreement preamble. So the truth is that we are not coming from a total unknown area, but actually from already lessons that we can refer to from the market mechanisms of the Kyoto Protocol, for example. And also there are, of course, a couple of other mechanisms, such as the finance mechanisms or also Redress, that we can refer to in terms of the question of public participation. And I would like to focus now, however, on the clean development mechanism, because we can actually have some clear parallels and learn from the weaknesses of the former mechanisms and what we have learned from that. So the CDM had actually already required local stakeholders to participate by sharing their comments on CDM activities. And the weakness was actually that it was not clear on how these comments need to be considered, nor more specifics on who needs to be consulted and also how this consultation should look like. So this was very much dependent on national decisions. And this has unfortunately led and shown the risk that human rights might be abused in such rather unclear framework. And this human rights violations had affected indigenous people's rights, but also other local communities. And we can also say that it has not only appeared in large-scale climate actions, such as, for example, big hydro dams, but also in small-scale climate projects. It has been seen that the lack of a clear participation approach has maybe not necessarily led to the violations of human rights, which is of course the worst case, but has led to the problem that the local communities were not informed about the activities, that there was a lack of transparency on what is going on. And this of course leads to the problem that they might not benefit from the project activities, or they might affect negatively livelihoods they depend on. So I'm saying this because we can really refer to numerous studies that have shown that the public participation part was not effective enough, and that the accessibility to this mechanism, access to information, and clear guidelines on how to deal actually with comments were not ensured, and therefore the risk of the effectiveness of actions can be really shown in a couple of studies, as said, not only for large projects, but also small-scale projects. So what we hope to see during this COP. At the moment, it seems like that local stakeholder participation is, or there's a rather bigger likelihood that this will be taken up in the text. However, it needs to be also strong enough, as explained, compared to the CDM. So there might be arrangements for consulting indigenous peoples and local communities, but this could be clearly weakened if we do have such text as appropriate or as applicable, because we will also refer then to a lack of transparency to the process. So it would be actually be the same problems or the same weaknesses as we have seen them in the CDM. At the moment, it's not sure if the inclusion of environmental and human rights safeguards will be included, which can have actually a clearer framework on what activities we would actually like to see in the Article 6. And the other element that we are advocating for would be an independent redress or complaint mechanism, because if something goes wrong and if the stakeholder participation has not been implemented in an effective and transparent and fair way, then of course you would also need the access to justice afterwards, and therefore we need an independent mechanism. So all those elements I also show you again in the next slide to just explain or conclude on why this is important. Apologies. So the part of access to information and public participation will ensure, of course, that there is an accessible and informed consultation process on how the activities will affect local communities, indigenous peoples, and other local stakeholders. And it will also allow for development and implementation of the project activities. So it must be timely and transparent, as said. So it would then clearly refer to the who and how this consultation is taking place. In addition, environmental and human rights safeguards would ensure that the activities are actually centered around human rights, gender equality, and indigenous peoples' rights, and they are actually leading to truly sustainable and transformative activities on a 1.5 pathway. And as said, the independent grievance mechanism would ensure that in case, even so the mechanism might be designed in a very strong way, if something goes wrong, that there is a way to justice for the communities affected. And just to close my presentation, I would like to refer to the fact that we do have the text basis and examples in practice from other UNFCCC mechanisms and instruments. So it's nothing new in the process, and we can rely on those experiences and should also from the past. Many thanks.
Thanks a lot, Patricia, for this presentation. And I must say, like, Article 6 is going to be at the core of the COP26 negotiations, and one of the agenda items that a lot of people will be watching very closely. A lot of civil society have expressed very strong concern with Article 6 in the first place, and are extremely concerned, including from a human rights perspective, that outcomes might actually further undermine the ambition of the Paris Agreement altogether from a climate mitigation perspective, as well as actually offer an opportunity for specific industry to continue to procrastinate on the path to decarbonization. So there are already some existential concerns on Article 6, and I think the presentation that Patricia has delivered right now really highlights the duty not just of the host, but also of every state participating in this process, not to accept any outcome under the Paris Agreement that will create a new mechanism resulting in harms for local communities and human rights threats. And when we speak about those threats, I think it's very important to understand that in the context of a clean development mechanism, the Kyoto Protocol mechanism that's used a little bit, unfortunately, as the example, as Patricia mentioned, people were assassinated for rejecting projects implementing in several countries without adequate public participation, projects that had received a financial incentive through the implementation of the Kyoto Protocol. So here we speak about really very harsh human rights violations for people and community leaders around the world. And so there is a very clear legal obligations for states not only to negotiate towards these strong human rights standards, but actually to refuse any new mechanisms that will actually lead to providing financial incentives that actually to projects that violate human rights at the national level. Now I would like to turn to the final conversations today before we engage in the Q&A and the interactive discussion with our audience. We'll hear from three different experiences of presidencies, first we'll give the floor to Sindra Sharma and Nakayeli Speight, who have been working with the COP23 presidency. So it was the Fijian presidency who in particular were in charge of the organization of the Talanoa Dialogue, which was an interactive dialogue taking place under the Paris Agreement to review the difference between the Paris Agreement's long-term goals and the actual implementation of climate policies. And then afterwards, we'll turn into a brief sharing of experience by Tatiana Shao about the challenges that some activists faced at COP24, not just about entering and having their voice heard, but you will hear the examples that will be provided is a lot more dramatic, unfortunately, and must really be in the back of the mind of all states engaging in the climate negotiations. And finally, we'll conclude with a very important message from Tasnim Essab, the Executive Director of Climate Action Network, on the challenges and expectations of civil society for the upcoming COP26 when it comes to public participation in the process. So I'll give the floor to Dr. Sindra Sharma and Nakayeli Bolo, Dr. Sharma holds a PhD in environmental policy and development and is currently working with the think tank IFRIGI, where she researches on multilateral and national development banks in transforming their investment towards a more low carbon portfolio. And Nakayeli Bolo is project manager at the Internal Displacement Monitoring Center, IDMC, and both have been working with the COP23 presidency that provided us actually some of the good practices when it comes to engaging the public and stakeholders in climate governance. So I'll give you the floor for a more positive message and reflecting on what is actually possible when presidency put these topics at the core of their priority.
Thank you, Sebastian, and thank you so much for the opportunity to speak with you today. And in the spirit of Talanoa, my colleague Nakayeli and I will be telling you the story of the process of the Talanoa Dialogue, which was decided at COP21 to be convened as a facilitative dialogue amongst parties in 2018. So I have just one slide for you today, so bear with me as I put that up, but I will give the floor to Nada, who was, like me, an advisor to the COP23 presidency chief negotiator, and we worked closely together on the methodology of the Talanoa Dialogue. So Nada, please take the floor.
Thank you, Dr. Sharma, and Bula Vinaka, as we say hello in Fiji, and I'm joining you from Suva, Fiji. It's quite it's 9 o'clock in the evening here, and it's a pleasure to be joining you all. The purpose of the facilitative dialogue, as we all know, was to take stock of the collective efforts towards a long-term temperature goal and to inform the development of nationally determined contributions of NDC. So in principle, the Talanoa Dialogue marked the beginning of the process of strengthening NDCs. The president of COP22, Morocco, and the president of COP23, Fiji, were mandated to undertake a more inclusive and transparent consultations among parties on how this dialogue would unfold. So at COP23, we had the privilege to design a process that we call the Talanoa Dialogue, which was welcome, and it was launched as a year-long process in 2018 and culminated at COP24 in Poland. This traditional Pacific Island way of dialogue approach this heated issue, as we all know, whenever we talked about emissions within the COP process. But with this Pacific way, it approached it with a more inclusive, transparent, and solutions-oriented process through a method of storytelling, with the intention of, one, bringing state and non-state actors on the same table. And it was critical for us. Hearing a lot of CSO voices was to really strengthen the role that CSO plays in the whole process and really enhance the active engagement in the process. And a core element of such communication, which maybe you don't often hear in multilateral decision-making spaces, is listening with empathy and understanding. Now, in a Talanoa dialogue, what we encourage was opposing views. Of course, we have to expect that in any dialogue. However, we didn't want to predetermine any expectation for agreement. The Talanoa participants themselves set the parameters for their discussions. In our case, inclusion, transparency, and mutual respect was a fundamental principle through this year-long process. And it was key, the process rather was key instead of the outcome. So because we believe that in the process of the Talanoa, it in itself helps to bind a community, a global community together, even when there is considerable disagreement. This Pacific style forum provides the room for all voices to be heard, and everyone involved has the right to express their views and opinions openly. And it is implicitly understood that those around them will respect what they have to say. So the dialogue was also in some ways a launching pad to what we can expect during the next assessment stage of the Global Stocktake, which is the Paris Agreement's ambition mechanism. The dialogue was further supported by the global climate champions who agreed to work with the UNFCCC Secretariat as part of the Talanoa dialogue process to develop events, promote knowledge transfer, even facilitate connections across actors and institutions, enabling transparency of progress on the non-state actor zone for climate action or NAZCA portal, and to support the aggregation of annual experiences in the yearbook of global climate action. So the dialogue had a preparatory and political phase. In the very first phase, it involved several mandated events, and it was more an interactive process. So we commenced with the launch of an online platform, sharing information about the dialogue, its process, how it's going to roll out throughout the year, and providing parties, non-state actors and state actors with resources to facilitate this full and effective participation in the process of all actors that are engaging in the dialogue. So the dialogue was framed around three very simple overarching questions to which we all here still today, and which were and where the parties were also invited, and the non-state were invited to make submissions. And the questions were: where are we? Where do we want to go? And how do we get there? And this question provided a space for pre and post 2020 inputs and discussion. And now I hand back over to Dr. Sharma to continue this presentation on the Talanoa dialogue. Over to you.
Thank you, Nada. And let me continue the story. So by April 2018, we had over 200 submissions, and the majority were from non-party stakeholders. These inputs provided a picture of the situation on the ground. The Fijian presidency prepared a report of these submissions, highlighting trends and stats and so on, which were then fed into the in-person dialogue, which was held in May, the subsidiary body's intersessional meetings. The need for synergy between complementary processes was noted, as was links between climate vulnerability, poverty, development, and suggestions of how to promote more rights-based climate action, sustainable development, and poverty eradication as well. Aside from submissions, non-party stakeholders also engaged in the Talanoa's Stories campaign, which was detailing innovative and inspiring action on the ground. The in-person dialogue offered an informal, inclusive, and positive setting that ensured an atmosphere of openness and mutual respect for non-party stakeholders and parties to engage with each other. And the intersessional dialogue saw a total of 207 party representatives from 162 parties and 98 non-party representatives take part in the Talanoa discussions. And they shared around 474 contributions, with the majority coming from parties and 105 by non-party stakeholders. Throughout 2018, the presidencies and their champions socialized and discussed the dialogue with everyone via a range of avenues, including workshops, webinars, forums, and also other relevant meetings. At the same time, all stakeholders were encouraged to have their own Talanoas to organize, strategize, and consolidate their inputs. The officially calendared dialogues amounted to around 90, but many more than this were held globally. So in the preparatory phase of the dialogue also included a space to consider the implications of the IPCC special report on global warming of 1.5. In advance of the wrap-up meeting, the COP23 and 24 presidencies also issued a synthesis document of the preparatory phase to provide a foundation for the political phase, which consisted of more high-level opening meetings and a set of high-level Talanoa dialogue roundtables and then a closing meeting. In that process, it was concluded with a Talanoa call to action, which was directed at governments, international agencies, non-party stakeholders, civil society, spiritual leaders, and youth, with the aim of fostering greater political will and action, including through enhancing financial, technical, and technological cooperation and capacity building. So now the dialogue was aiming to bring many voices together in positive collective action. The conclusion perhaps was not as strong as we would have desired. The COP24 decision text took note of the outcome, inputs and outputs of the Talanoa dialogue and their potential to generate greater confidence and courage and enhanced ambition. And it invited parties to consider the inputs. Of a total of 473 inputs to the online platform, only 9% came directly from parties. It was argued that the dialogue did not really provoke the baseline data gathering from the first questions of where are we now, and consisted of a collection of ideas rather than a set of conclusions, which may have faulted the ability to forward policy making in the how do we get there question. But we must recall the time in which this occurred as well. So, you had waning political will from heavyweights like the US to consider as well. It was nevertheless a mechanism through which to coordinate non-party stakeholder input, participation, and integration to further advance the goals of the Paris Agreement. And for the Pacific, in presenting this specific way of communicating to a multilateral process for which small and vulnerable groups have often fought for space, Fiji was able to use its leadership role at this level to counter representations of Pacific Islanders and more generally small island states as passive victims of climate change, and instead being active creators of solutions and offering a more bottom-up and proactive space for all voices and stories to be heard. So this is our Talanoa story, and with that, I hand back the floor.
Thank you so much for these interventions in this presentation. I think we remember the Talanoa dialogue as an example of a presidency really being tried to go out of the way to actually ensure a more inclusive and participatory process. Before I hand over to a very different type of examples of engagement of civil society or challenges with regards to the right of public participation in the context of COPs, I would like to invite all of you again to use the question and answer option that you have at the bottom of the Zoom screen to raise questions that the panelists can answer. And we might, if you would like to make your interventions orally, we could give you the floor also afterwards. So do not hesitate to type your name so we can provide you with access to the microphone to join the interactive conversation in a few minutes. Unfortunately, now we must turn, and I think it's very important that we hear also the following intervention from Tatiana Sharon. We must turn to the challenges that stakeholders have faced, or civil society representatives have faced trying to come to the COP to participate, not only not being sufficiently heard, but you will hear this example of what some of the activists are facing as being something of a very different scale. Tatiana, I give you the floor, and thank you for joining us to share your personal experience.
Thank you very much, Sebastian. Can you see my presentation?
Absolutely.
Yeah, thank you. My presentation will be very, very different from other presentations that were done today, but I still want to thank everyone for being here and for this opportunity to that was given to me. And I really hope that people who need to hear this message from me will hear it and will act on it. My name is Tatiana Shaura, and I'm a climate activist and a communications expert. For almost 2 decades, I have been a part of the environmental movement in one of the most difficult parts of the world. No one here is probably aware of what the ECCA acronym means, but I will tell you. Eastern Europe, Caucasus, and Central Asia, a region where almost each country is under dictatorship, but also a region where I have my family, friends, colleagues, and loved ones. I am used to repression, fear, police brutality, prisons, torture, and death. We all are in ECCA region. We know that the European Union is not perfect, but we know that justice has more chances in the European Union. On November 30th, 2018, I was taken off the train from Moscow to Warsaw on the Polish border, put in isolated room. You can see me here. Under pressure and lies, I was forced to sign documents in Polish language, which I don't speak, driven by the Polish military representative to a Polish border, put in a car with a stranger and asked to drop me on the other side of the border to Belarus. No, I'm not a criminal. I'm a climate activist who was just trying to attend the United Nations climate negotiations COP24 in Katowice. And just because of that, I was proclaimed to be the threat of the national security of Poland. This was not my first COP. I had all my documents ready, including accreditation from the UNFCCC as an observer. I start my preparation for the next COP when the current one finishes, because it is extremely hard to get any support for participation outside Western world. And if you do get the support, you have so many responsibilities that getting you out of the equation affects many, many events, meetings, activities that other people depend on. 14 other climate activists were restricted to enter Poland or deported in December 2018. Most of them are from the ECCA region. Konstantin Krynicki, Ukraine, escorted in handcuffs by the border guards from his hotel in Katowice, together with his colleague, to another town nearby. Personal belongings were confiscated, including mobile phones, with no possibility to contact him for 12 hours, found by representative of the Ukrainian embassy, who helped to get back to Ukraine safely. Oh, sorry, this was another picture of from the Katowice March. This is Nogzar Kochriidze from Georgia, accredited by UNFCCC as a Georgian government delegation member, was stopped at the border, taken to the cell in the airport, suggested to leave with the next flight or being deported, refused to leave as there was no legal reason, and spent 5 days in the cell, after which was escorted to an airplane by force. It was supposed to be his first COP. Irina Sepelnyak, Ukraine, stopped at the border, taken to the cell, escorted by police carrying guns to the flight back to Ukraine. It was supposed to be her first COP. Maria Kolesnikova, Kyrgyzstan, stopped at the border, turned back to the flight to Kyrgyzstan, was forced to sign documents in Polish language, and when refused, was intimidated that her name would be red listed for future EU visits. It was supposed to be her first COP. Olga Boyko, this was the document we were supposed to sign. And Olga Boyko was traveling with 12 other colleagues from Ukraine to Poland by train. Only 8 people made it. 5 others were declined entrance after their passports were checked. And this is what she said. After arriving to Krakow, we immediately started writing press releases about our colleagues being detained. We came to Katowice the next morning and felt like every police car in the city was after us. We felt very unsafe. The same morning, our colleague Konstantin wrote that he was detained. We didn't hear from him for 12 hours. Addition, 2/3 of KNCCA Secretariat was refused entry to Poland, coordinator and communicator. I was comms assistant by that time and had to take over all the plans we had in mind for COP24 as KNCCA Secretariat. It was the most surreal COP. Many others afraid to speak up as it can hurt their visa history and a possibility to travel. For some, it already did, and for me, including. And others just feel that my speech is pointless because no justice is done for us. We fought against, we went to the court, we tried, but no answers were given and no one was punished for this. Some Polish officers were very clear that all of us are on red list because of COP24, and we are very welcome to come to Poland after the conference is over. How generous. Today, this speech is my last chance to demand justice to my post-Soviet colleagues and for anyone else who experienced unjust restrictions to participate in UN climate negotiations, making sure the progress is made and not dirty business that leads all of us to approaching climate catastrophe. Oh, sorry, probably you cannot hear it. I will stop sharing and I will start sharing again with my sound. Sorry. Just a second.
I want justice.
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 For some of us, this will be the first time justice will be witnessed. I want to believe Aarhus Convention is not just a piece of paper, and this is not just another online meeting that we all are tired of. Thank you so much.
Thank you so much, Tatiana, for having shared your personal experience and that of many of your colleagues. And I must say that unfortunately, these very dramatic incidents, they actually are not isolated. And we have seen previous COP's presidencies for which the media or the United Nations agencies have also reported violation of human rights of some of the environmental leaders, whether being France, Denmark, Morocco in the past. So just those issues are present. And unfortunately, they do not only apply to countries far away from the Aarhus Convention core region, but also have materialized for many of the European hosts of the COP. I think it's important for all of us to hear this message, to understand the long-term implications of these human rights violations that have been faced by some of the activists trying to come to the COPs, but also actually to make sure that we take it as a collective responsibility to ensure that this never happens again, whether by the presidents, by putting increased pressure on the presidency to meet their human rights obligations, but also by demanding that other parties engaging in the negotiations actually follow up with presidency and ensure that international climate convenings they participate to actually take place according to human rights standards, and that activists have the ability to come to those meetings when duly registered, as was the case for Tatiana and the others. Now I will transition to Tasnim, but please really I invite you to raise questions. There is a question in the chat about environmental human rights defenders, and I'm afraid that Tatiana was a very good example actually of the challenges faced by environmental human rights defenders in the context of COPs. Tasnim? Oh, sorry, Tasnim is probably known to many of you. That's why I forgot to introduce her, but she's the Executive Director of Climate Action Network International, which is the largest network of civil society organization working on climate change. I will give her the floor right now, but she's doing, of course, incredible work trying to convene so many different voices from civil society and support their active participation at COP26. Thank you so much for your leadership, Tasnim, and I give you the floor.
Thank you very much, Seb, and greetings to everybody. And it's really difficult to, in fact, make an intervention after listening to Tati's colleagues' experience in terms of the injustice served on them. And I really hope that justice can be served. Now, Tati's experience is an extreme form of injustice related to the attendance of a UN a very important UN event, the COP. And what we have to talk through is a spectrum of experiences. So before I pivot to COP26 and what that's going to look like, or has already started looking like, I want to talk about another moment now that we've spoken about the amazing and inspiring experience of a Fijian hosted COP through the Talanoa dialogues, through to this experience in Poland. And let us not forget what happened at COP25. And I think, that experience in Madrid, where inside a UN precinct, the harshest form of criminalization of activists took place. Inside a UN precinct, when the security forces were set upon peaceful activists demonstrating peacefully inside the building, making demands for a higher ambition on climate change, and they were physically manhandled and evicted. An entire over 300 activists put out into a courtyard and kept there. And many of them, of course, all of them were debadged. There was hard negotiations to get them back in, but 3 of them remained debadged. So if we deal with Tati's experience, and then we look at these, what we almost in a sense are taking for granted, the ongoing diminishing and shrinking of civil society space inside UN processes, then we should understand that we're not dealing with real justice, the real protection of rights of people, and in no way are we talking about meaningful public participation in these processes. So I want to start out by saying everything is not rosy in the UNFCCC process. We've been working hard with the UNFCCC Secretariat since Madrid to look at different ways of securing the space, to look at peaceful, non-violent approaches to dealing with civil society and civil society activists, and we'll continue that engagement. But let us pivot towards COP26. And it's interesting, Tati, that you spoke about red-listed countries. And in this way, red-listed in your circumstances different to red-listed during a pandemic. And many of you would know that the Climate Action Network took a very difficult but important decision to shine a spotlight, to ring the alarm bells on what was clearly becoming a situation around the organizing of COP26 that would not have, in fact, secured safety or inclusive participation by not only observers, but even party delegates. And of course, we understand that the pandemic comes with its own challenges, but the way you deal with this as a host of a COP has to recognize that fact, that there would be logistical difficulties, for example, and obstacles to get inclusive participation at such a COP. And we were demanding for a long time, not just CAN, but all of the constituencies in the UN, the observer constituencies in the UNFCCC, to see the plans so that we could also help the host of this COP26 to guide them, to suggest, things, the details that they might not have thought through that could be obstacles to participation. And that was not forthcoming. It needed a massive, very difficult decision by this network, who's fighting a climate emergency for decades, to call for a postponement of this COP so that we can actually shine a spotlight on these difficulties. Now, what were these difficulties? People might think, oh, but why is it so difficult? Well, the main impacts of course, of inclusive COP26 is mainly with those delegates and observers who come from the global south. And here, the pandemic and the climate crisis and how we address it converge. Many of the developing countries from the global south, you will know, had a problem, still has a problem with access to vaccinations. And while rich nations were able to vaccinate the majority of their populations, and some of them even able to provide their population with a third vaccination, many of the poorer developing countries were not even able to vaccinate nearly 2% of their populations. And so in that context, and in the context, therefore, of countries being red-listed countries, and this has changed now, as we know, many have been taken off the UK's red list. In such a situation, there were a number of problems. One, getting into the UK in the first place. Two, many of these activists who are coming from the global south who are not badged. And you know that the importance of civil society participation at the COP is not just inside the process, inside the blue zone, but it's everything else that happens around the COP that is important. The Global Day of Action, the People's Summit, and all those actions that take place, etc. And even people who are going to attend the Green Zone activities, by the way, that Salka spoke about. Those who come from red-listed countries have to quarantine for 10 days in a hotel that they need to pay for. Now you tell me what grassroots activist can come to the UK and spend all those pounds for 10 days. That's already one obstacle. Then we talk about travel routes. Many countries, because of the pandemic, you'll have to, it's not a simple thing as hopping onto a plane, getting to Glasgow, because you have to be rerouted and flights are not available, etc. There's another practical obstacle. Then when we're talking about, the health costs, if you get COVID while you're at the COP, you pay for your health costs. You will also have to isolate if you, and your colleagues, if you've been in contact, etc. So just the pandemic itself and the logistics related to that caused a number of obstacles. Now people might think, but these are logistical things. But logistics are deeply political. How you manage logistics, how you design logistics, how you plan for logistics is deeply political and can result in exclusion. In this instance, we suspect that many observers, civil society members from the global south, especially those from poorer nations and some from vulnerable islands, will not be able to make their way to the COP. And so we needed to send a very strong signal that the UK government was not on track, even though they declared it, to have this normal, the most inclusive COP ever, because it was not going to be practically possible. The UK conceded to at least one of the demands, and that was that they were going to pay for quarantine costs for badged civil society and parties, badged. That means grassroots activists who are not badged will still have to face all those obstacles. Now, I'm giving this example because, we've heard from the UK COP presidency. We've heard what they, all these bodies that they have set up that appear to be inclusive. And it's important and it's good that they've done that. But there are other constituencies sitting on this panel who would tell you very clearly that we had fought for quite a long time. In fact, nearly 2 years, because the COP was supposed to be happening last year, for just the simple recognition of the constituencies in the accredited constituencies in the UNFCCC. So what had happened was the COP presidency decided to set up all their own bodies friends of this, advisory committees on that, etc. And they were just marginalizing the traditional constituency groups in the UNFCCC. And it nearly took a year to get them to actually acknowledge that we exist, that we're very important players in this process. So the other thing that I need to be very clear about in the UNFCCC process, and it's not just this UK hosted one, is this notion, and we keep on hearing when we raise the issue about, but observer participation, everybody will tell you that, from the institutions, oh, but we've got the most observer badges ever. We're hearing the same thing with this COP, that there's been so many new organizations from civil society getting badges. Now, greater numbers of badges for civil society does not equal meaningful participation in the UNFCCC process. Let us be very clear about that. And when we talk about meaningful participation in the UNFCCC process, it would be really good for all parties, for the Bureau, for the Secretariat, for the COP hosts, to understand that performative participation is not what we're asking for. Giving us 1 minute intervention in an opening plenary, whether you're ahead of a minister or after a minister, 1 minute intervention per constituency generally is not meaningful participation. Being shut out of negotiations, and we had this experience recently in the SP session, when one party can tell you, you're not allowed to be here, and then you shut out as observers. In a transparency, mind you, in a negotiation on transparency, you shut out. So we have huge challenges about participation, meaningful participation, not this notion that if you have a badge, if you have a 1 minute intervention, etc. And so I think that we are going to have to, this is not going to come, the decision makers are not just going to automatically, it seems, understand what we are saying when we ask for meaningful participation. So it's going to be up to us as civil society to constantly be rattling the cages about this, that we need to be respected as equal partners in these processes that address a global crisis. And that would mean the transformation of the UNFCCC itself. It is not designed or fit for purpose to address a global crisis. The format of a Talanoa dialogue, for example, is totally inspiring. That if we had a system that from its start at a national level is inclusive and meaningful and participatory, and through the value chain, when you arrive at an international meeting, we are all sitting around a table trying to find solutions to this crisis, or holding governments to account for inaction, etc. That is a very different idea of meaningful participation. So we are coming to COP26. We are going to keep the feet to the fire. We are going to demand our space. And one of the things I think what we have to do, and it'd be great to hear from the legal experts as well, we've signed all these conventions, but codes of conduct that we are all going to be signing to get to COP26 often are not consistent with these conventions. Right? I mean, we were treated in the way we were in Madrid because of a code of conduct of a UNFCCC. What if there is inconsistency between these rules and procedures and practices to conventions that have been agreed to internationally and by parties? And so I think we have to become far more active in ensuring consistency in terms of conventions and legal frameworks. And I think we must start raising our voice strongly. We are not an irritant. We are not criminals. We are peaceful activists fighting for a better future for all of us. And of course, now the UN Human Rights Council, as you said, Sebastian, has further strengthened our hands for that. And I hope that those agreements will be respected when we go to COP26. Thanks, Sebastian. I will leave it at that.
Thank you very much, Tesnim, for another very powerful intervention before we conclude the panel. So now we have a few more minutes for the question and answers. I've seen some questions already, not only asked in the Q&A function that I really encourage everyone to use, but already answered by some of the other participants in the chat. So I welcome this engagement and invite you to continue using those tools. Without further delay, I will maybe turn back to some of the panelists to ask you if you could maybe either comment on each other's presentations or also address some of the questions. I know questions related to environmental defenders. There is a question by Nicola Sherman about the difference of rationale for public participation in climate governance. And this is a very good one, actually. A lot of the actors are engaged in climate governance, are welcoming voices from the perspective of stakeholders contributing to climate action, so welcoming businesses also taking some form of climate action. That's an interesting rationale, but a very different one from the right-based rationale that we are discussing today, the democracy-based rationale that actually is not so much about efforts that the presidencies are taking to engage specific groups that they work with more closely, but actually about making sure that everyone who has who has an interest in the process can actually come and intervene without any filter, of course, through some modalities, but without those challenges that Tasnim and Tatiana in particular have stressed. There were some questions also about what is effective participation, and perhaps also on these incidents that was discussed in Madrid by Tasnim, and why this is actually a real challenge, despite the fact that this happened, or even maybe even more real challenge because it happened within the perimeter of the UNFC COP. But do not hesitate to comment on each other's presentation. I'll suggest to go back in the order that we went through. So maybe Special Rapporteur Vul, if you'd like to comment.
So, sorry, Sebastian, I'm not sure I get your question. I was trying to read the question in the Q&A.
I have no specific question for you. It's really if you have any comments on other presentations on some of the questions.
Oh, yes, of course. Yeah, I think some of the issue that was shared by other panelists confirm also what I find in my report that I will be presenting in General Assembly. That today we cannot continue if we are serious in reversing the ongoing global warming, climate change that we are fighting. We have to be honest to say that we can no longer continue restricting communities, but also defenders and environmental leaders that are fighting for and advocating to reverse the situation. And in my report, as I highlight, it seems to me that states are not really, or many states do not understand really the level of their own commitments and continue to kind of behavior as we are still in a situation where we can tolerate certain behavior against the planets, because we know that we reach the point where if we don't do anything today, then we are completely, we will completely lose the battle. And we can no longer continue to allow states, because this is not just about it's not about the sovereignty issues. It's about our survival as planet, our survival as human being. And we can know, that's why I'm saying, and I'm emphasizing this to the General Assembly. Climate advocacy on climate change, protection of climate is becoming a duty and it becomes commitment for all of us. Any state should not be hiding behind his border and say that this is my sovereignty, because it's no, we will either we survive all of us or it's the end of all of us. So that's why for me, it's important today to recognize and to celebrate the activism of climate justice activists today, because they are the one really that are shaping the policy that we are seeing today. And also the awareness of some states now to take measure is really those young people, is really those communities that are stand up today. And we have to encourage them if we want really to move reverse the situation today. And for me, it's also important that states goes today beyond the politics and understand the gravity of the situation. The Secretary General Guterres mentioned that during his speech. And today we need action on climate issues. We don't need anymore to continue this game of politics of who is the bigger emitter. No, we have today a situation where we have to deal with it with international solidarity, but recognizing that we cannot achieve this without public participation, without involving those who are affected, without involving communities. So for me today, this is the message that I'm planning also to convey. And this confirmed, you talk about the Poland COP24, where we did some communication during this process and have discussion with authorities. And I think today, preventing people to participate and to have access to the international fora where they can also convey their message, it will be hindering all the possibility that we have today to reverse the global warming, to reverse climate crisis today.
Thank you, Clément. And Anastasia would like to go next. And I see some additional questions coming. So thank you so much to the audience. If someone would like to take the floor, we'll give you the floor. Just raise your hand. Otherwise, we'll try to have panelists answering your questions. I also invite panelists to use the written function to answer questions that are being posted in the Q&A function. And Augustine, I see your hands up. I suggest to give you the floor after Anastasia's comments or thoughts.
Thank you, Sebastian. And I just wanted to mention that as the Special Rapporteur on the Rights to Freedom and Peaceful Assembly and Association have stated in his report, over 70% of human rights defenders killed every year are involved in the protection of the environment. And we also heard the terrible experience of Tatiana at COP24 in being denied participation and justice. And I would just like to point, also responding to one of the questions, that the Aarhus Convention specifically deals with the protection of environmental defenders. And this is at Article 3, Paragraph 8, and I will just read it out. Each party shall ensure that persons exercising their rights in conformity with the provisions of the Convention shall not be penalized, persecuted, or harassed in any way for their involvement. And to address the increasing concerns and threats to environmental defenders, a proposal has been put forward by the Aarhus Convention Bureau for the establishment of a rapid response mechanisms that would protect environmental defenders. And this establishment of the mechanism will be discussed at the coming MOP, will be subject to discussions, and it will be in the form of the mechanism will be in the form of an independent special rapporteur to provide a rapid response to any alleged violation of Article 3.8 of the Convention. And any claim would be addressed specifically to this rapporteur who would provide an immediate response. And then I would just want to comment on Tasneem's presentation and on recalling what I've mentioned also in the presentation about the Almaty guidelines, in particular paragraph 15, which reminds and recalls that parties to the convention, including the UK as host government of the next COP in Glasgow, have to ensure a balanced and equitable process within international forums. Thus, there is they must ensure also that there is support to facilitate and the participation of those constituencies that do not have the means to participate and face the hurdles that are represented by the COVID pandemic in place. Thank you very much.
Thank you, Anastasia. And this is something, paragraph 15 of the Almaty Guidelines, an instrument that we look forward to working further with under the Aarhus Convention. The Aarhus Convention is about to mandate more work on what it means to be equitable in participation. And so more news will be coming, I guess, next week at the time of the MOP. I'll give the floor to Augustine and then to Tatiana, if Augustine wanted to take the floor again. And I will, if that's okay for all of the participants and panelists who can stay with us for just another 10 minutes, we'll try to have a full round of feedback and comments for those who are still able to spend a few minutes with us so that we can hear brief reflections from all, and then we will conclude the event. This could lead to very rich conversations, and unfortunately, I'm afraid we'll not be able to have all of us today, but it's just the start of a continuation of a long-lasting conversation, I guess, on those issues. Augustine? I'm not sure if it's an old end or a new one, so why don't we go to Tatiana, and then Augustine will hear you afterwards, if that's okay.
Should I go? Yeah. First of all, thank you, everyone. It was really a big pleasure hearing all the presentations, and I want to say that Anastasia, the initiative that you're doing is really important. I'm really hoping it's going to be working, and I would like to. I wouldn't want there to be a situation for people to have to use this, but I think it will occur over and over again. So I appreciate that this process is happening. For my feedback, and my last thing that I will say is that I feel like the CSO participation in the United Nations processes and in any other governmental processes is just like a checkbox. For example, like having a CSO representative in some panel, check. Having a woman representative in some panel, check. Having someone from the South, check. And that is not okay. And that's not what we're here for. And we do not want to be used to justify that this panel has been inclusive if it doesn't benefit those who were included. And I feel like UN and the governments are obviously living in their own bubble, and they do not understand how hard it is for us to organize anything and be included, how much resources it takes, especially from those who are not from the Western world, especially for those who are like the most affected and who don't have EU passport. And it's enormous day-to-day struggle to be included anywhere. And I want for this understanding to come to the minds of those who are making decisions. And I would be happy to be a part of that. And I hope that it is even possible.
Thank you so much, Tatiana, for flagging this checkbox issue. And we've just been invited actually to nominate a civil society speaker on a panel with a lot of governmental delegates, a lot of white males in particular, being told that we need a civil society Black woman in order to balance the panel or from a minority, just highlighting this sort of one speaker tick all boxes for inclusiveness and something that really should not be taking place in the 21st century anymore. So moving beyond tokenism, I think, is the key message here. And I guess that's where human rights frameworks can help us understand what actually are the standards. I will actually paste in the chat link to a document or resource that CL produced on some of those issues of civil society space at the time of COVID in international governance. Will any other panelists like to take the floor? Or Augustine, are you ready to make another? Oh no, you lowered your hand. Okay, excellent. Next panelists would like to take the floor. I think we have Tasnim. Augustine is back with a hands up. Why don't we hear Augustine very briefly and then go to Tasnim?
Thank you very much, Sebastian. I had problems with my internet, so I couldn't respond at the time you asked me to do so. Yeah, I am happy with the presentation from Tasnim, and I think we also in the civil society should show that in practice we like consultation, we like effective participation of stakeholders even in our civil society processes. As much as we're asking the governments and the public sector to be inclusive and consultative, especially the most vulnerable people with the most vulnerable people, we should have, and my appeal here is that as civil society, global civil society, we should make sure that this is happening even amongst us. What is the part of developing country civil society organizations in the discussion, in participation, in decision-making in the global civil society movement? Maybe those are some of the things that when we meet at COP, we could also have a session on that. The governance within us, the upholding of the Aarhus principles amongst us will be very necessary, because we don't like to see a situation where we're asking for something from one part of one party and then we're not able to deliver it to ourselves. So this is a very good opportunity for us to sit down and also talk and see how the global South civil society movements that are independent and that have their own thought, that have their own voice, how is it taken upon by the global, especially Northern civil society organizations? Those are some of the things that we can discuss amongst ourselves. Thank you very much. And again, thank you for this presentation, Tas.
Thank you, Augustine, for this very important message. Tasnim, and then perhaps we could go to Sindra.
Yeah, no, thanks very much. And thanks, Augustine. I think you're absolutely right. And we should use the opportunity of our gatherings again to facilitate those discussions. Absolutely agree that, the issue of Global South participation, Global South civil society, independence and voice is a critical element. It's one of the things that our network, for example, even in our own decision-making now has moved very clearly to accepting that Global South, the Global South part of our network has voice, is leading. And so, yes, agreed that in the wider civil society space, we need to also convene and have those discussions. The one thing I wanted to raise, Sebastian, because, when we made this difficult call as CAN, there obviously and absolutely acceptable that there were critical voices around the call for, for safety and inclusive participation at this COP. Many were saying, but, the climate emergency, we're in a climate emergency. And so we cannot accept this kind of call for a delay or postponement, etc. Now, I want to be very clear. Of course, we're in a climate emergency. But there cannot be a trade-off between dealing with a climate emergency and guaranteeing equitable access and inclusive participation. When we start doing those trade-offs, then there's a slippery slope of securitization of the emergency. Be very careful about this. We get very, of course, we are all passionate about fighting the climate emergency, but it cannot be a trade-off against fundamental human rights. And that's a warning, actually, because all of us has watched democratic rights and spaces being taken away from us under the guise of all kinds of emergencies, And we've experienced this during the pandemic. So I just want to make that very clear. And nobody should doubt the commitment of climate activists who have been fighting this climate emergency for years, but will also fight for their human rights, their equitable access, and their inclusive participation.
Thank you for highlighting this.
If I may just say one brief thing. The reason I'm saying this, exclusiveness or inhibitants for participation of CSOs is not new to us. If you look just at the applications for visas, especially when the COP is taking place in the north, in European countries, developed countries, if you look, I don't have statistics, but from our networks, many people are refused visas. In fact, many, if we are 100 of us who have applied for visa coming from Africa in particular, if they give 25 people, then that is much. That is from my own gaze, from the experience we've had for 30 years. So being prohibited from participating effectively at COP is not new to us. Secondly, even the cost of attending COP, when you go for a visa, they ask you whether you have a bank account that is having some money into it and all those kind of things, prove that you will come back to your country. Those are some of the things that we've been crying since Copenhagen. We've been saying this. I raised the issue of Aarhus Convention in Copenhagen in 2009. In fact, we were kicked out. Me, personally, I was arrested in Copenhagen. It's thanks to the press that was there in the open space and the solidarity of African delegates that I was released and my badge was given back to me. Those are things that we have been struggling with as Africans. But when we bring that into the global civil society movement, it's like our voice is different. But I'm happy that we are now more conscious. And so in order to tread well in this on this domain, let's have this discussion and see how we have been struggling on these issues of being prohibited from attending COP. And let's be frank and open to ourselves. We are not in any way doubting those who have thought that this COP should be postponed. The reasons are very valid. But from our own perspective, we say these are things that we've been used to, we've been struggling. Now that COVID has only come to compound the climate emergency, we cannot guarantee that postponing it will make better participation for us. So why not just go ahead and then do it and then continue with this movement to make sure that there's more transparent and effective participation, especially from the global south. That is what we mean. I think I'm happy that many more organizations are now seeing that this prohibition or inhibition from effective participation has been ongoing. And for us, the message we are sending is that it is not a new thing. We are used to this. We are used to being refused from participating effectively. First, the cost, they're very high for us. When coming to Morocco, people should understand something. COP22 in Morocco, the Moroccan government, when we said it is very costly, Moroccan government made it possible for us to have hotels for free to show that they wanted participation, and it was very effective. So those are some of the things that I think the bigger organizations should listen to grassroots organizations, and let's talk these things very effectively and frankly and see how we can move together, because stronger together we are. Thank you very much. I'm sorry I have taken the floor for too long, Seb. I will not speak again, but I thought that this was an opportunity for us to have this discussion.
Thank you. No, absolutely, Augustine, and I'm glad you did. I really thank all of the panelists and the participants who stayed with us for a few more minutes. I think this message was also very important for all of us to hear, including civil society, because we have a lot of homework clearly to do. What I will suggest is that we wrap up now briefly with two final comments from Sindra potentially, and perhaps Patricia, if there is anything that you would like to come back to, or any points that you would like to echo that were made by previous panelists or raised in the questions, and then we will just conclude this event. Thank you so much for staying with us and bearing with us for this slight extension of the event. Sindra, would you like to go?
Yeah, thank you, Sebastian. I'll be really brief. I guess on the question, what does effective participation look like? I think if we're in a climate emergency, and as this is a collective and global problem, I think the way to have effective participation would just be to give people a seat at the table, right? So you just need to have that opportunity to speak your truth as well. And And I think we need to learn from the lessons of RED+ and the Clean Development Mechanism. And we need to have that seat at the table during the negotiations of Article 6 and other processes.
Thank you. And that's actually a very good bridge, I believe, to Patricia's.
That's true. And just to underline that we really need the power of everybody being in Glasgow or not in Glasgow is to make sure that the human rights are really effectively integrated into the Article 6, because at the moment there is the high risk that not even this utilitaristic view of public participation is helping to effectively implement an action is considered. So I really hope that we can join forces in all layers for the content of the negotiations, and of course also for our participation in Glasgow, because there is a risk that COVID-19 will really reduce further our right to, for example, have actions and raise our voices. So we really need to have this joint solidarity from all around the world. And I'm really looking forward to continue talking about this topic. Many thanks.
Thank you so much for those final words. I will just conclude then, not to take too much time, but I think we've heard today about the importance of the right of public participation, the duty of states to protect the civic space in the context of international climate negotiations, the fact that a right-based approach means providing effective participation for any members of the public who believe that they should have a voice in the process, and not just this sort of box ticking or self-selection of participants from the side of the hosts of COPs, and the priority also to prevent harms and human rights violation, whether in the context, for instance, of outcomes like Article 6, where actually activities might be incentivized that will harm local communities, but also in the context of protecting the rights of those advocates who are trying to come to attend, to participate, to engage in the COP process, and who have seen their rights denied with very long-term consequences. And so I think those issues must be at the core of civil society's engagement. And I think Tasneem's intervention also reflected the priority that civil society groups coming to the COP actually dedicate to these issues. But also we've heard from the Special Rapporteur, Clément Voul, from Anastasia Giadrossi with the Aarhus Convention Secretariat, the fact that there are very clear legal norms that actually impose obligations on states to protect, promote, fulfill those rights in the context of national climate policies, but also international climate governance, not only for the host of the president of the COPs. And we've heard the example of Tatiana, I think, really highlighting how challenging situations can become, and the need then for greater support actually for advocates and activists that are becoming the direct target of this kind of harassment, but also the duty of every state engaging in the process, in particular, of course, the parties to the Aarhus Convention, to the Escazú Agreement, to really make sure that those conferences do not end up being the location of human rights violations of advocates, or seeing advocates being denied even entry into the territory of the states hosting. I think we have a final request for the floor from Clément Voul, and then we will just take this as the final comment. I will just thank you on behalf of the organizers, the Center for International Environmental Law, the European Environmental Bureau, and Earth Justice for joining us today. Clément, you can conclude the event.
Thank you very much, Sebastian. Sorry for taking the floor again, but I thought that it would be important for me to make really this call for the states. And I think we need also to highlight that the Intergovernmental Panel on Climate Change already recognized that the important role that civil society play in really mitigating and reversing this climate crisis currently. And it's important, as Antonio Guterres saying, that we are also at the moment where we break down or we break through. And depending on what we will be doing today, that will be conditioning the future of crisis that we will face around the climate change. For me, it's important today to call states to really respect their pledge, the pledge that they are making around COP26, and ensure that civil society can participate effectively. Not just, as Tatiana said, to tick the box, but also seeing them as an important player on reversing the climate crisis. And we have to ensure that states make this the commitment they are making, that they implement them. If we are not able today to ensure the participation of civil society, effective participation, meaningful participation, then we will not meet the goal that we aim for ourselves to reverse the climate change. And we have little window opportunity today to reverse that. Either we decided today to make the best choice of having civil society an important actor, as an important player, both at the national level, international level, or we will then go into breakdown. So it's important that we take our responsibility today. Each state needs to take their responsibility today to ensure the meaningful of participation of civil society. So thank you, Sebastian, and thank you also for organizing this important panel. Thank you.
Thank you so much. And we'll share actually in the final email sent to all participants, both a link to this recording, but also a side event that actually Clément Vaul is hosting to present in more detail his report on the civic space and the climate justice struggle, which is taking place later this week on Friday. I will share this, the invitation to all participants today. Thank you so much for joining us today. We look forward to engaging and working with all of you in this very important struggle for a truly participative and democratic transition away from fossil fuels, and to strengthen the resilience of all of our societies. Thank you all, and we look forward to continuing this work with you.
Thank you, everyone.
Thank you.